Paging Aitken Robertson to courtroom number 2. The jury is back with a verdict. Members of the jury, how do you find the accused? Guilty or not guilty?
Not guilty on all accounts, Your Honor.
Hi everyone, welcome back to Legally Speaking. I'm Melanie van Orde, your host and paralegal, and today I'm here with criminal lawyer Richard Aitken to talk about a very complex but critical topic, the kinds of evidence that are and aren't admissible in a criminal trial. Hi Richard, thank you so much for being here. Okay, so let's start broad. How do the rules of evidence in criminal trials compare to other types of court cases?
That's a great place to start. The rules of evidence in criminal trials are some of the strictest. Everything presented has to meet high standards to ensure fairness and reliability. Compare this to something like child welfare court, where the rules are much looser. Almost anything goes in and can be presented as evidence, although the judge decides how much weight to give to it. Hearsay, not a problem. Double hearsay, not a problem. Well, it's a problem in criminal court.
So the stakes in criminal court mean that there's stricter rules?
Exactly. The goal in criminal trials is to avoid wrongful convictions by ensuring that only the most reliable, relevant, and fair evidence is considered.
Okay, so let's talk about direct evidence. What is it and is it admissible?
Direct evidence, Melanie, is straightforward. It comes from someone who personally observed or experienced something related to the crime. For instance, if John testifies he saw Billy stab Betty, that's direct evidence. It's admissible. And both sides, prosecution and defense, can cross-examine John to test his reliability. It's admissible, and both sides have a chance to explore the evidence with the witness, one with examination in chief, and the second by cross-examination.
And what about hearsay evidence? I mean, that's something we hear a lot about in the legal discussions.
Hearsay evidence is when someone testifies about what another person said or experienced rather than their own firsthand personal experience. For example, if John says, Brenda told me she saw Billy stab Betty, that's hearsay. It's generally not admissible because Brenda isn't testifying herself, and the other side can't cross-examine her about what she saw. It's unfair.
Okay, that makes sense. It would be unfair to rely on secondhand accounts. But then, are there any exceptions to this rule?
There are many exceptions, probably over 100. We'll go through a few of the major ones. Key exceptions to the hearsay rule: res gestae, in other words, spontaneous utterance. If someone makes a statement immediately after an event, like Betty yelling, Johnny stabbed me, it can be admissible as a spontaneous utterance. The idea is there wasn't time to fabricate a statement, so it's considered reliable. Business records, like hospital charts, weather reports, accounting records, can be admissible if they're kept in the normal course of business and a proper foundation is established. This often involves giving notice to the other side and filing an affidavit from the person in charge of keeping the records. Utterance in contemplation of death, a statement made by someone who believes they're about to die, like saying, my brother Ray shot me, is considered reliable because the person wouldn't likely make a lie in such a statement when they're about to meet their maker. A KGB statement. Now, this is not a statement given to the Russian secret police. It's a case called KGB. It's a sworn statement, usually video recorded, taken by police. For example, in a domestic violence case, if the complainant later changes their story, the KGB statement can be used as real evidence instead. So in the KGB statement, the witness swears under oath as to what happened. If that witness changes their mind, all of a sudden says, oh, it's not really what happened, the Crown plays the KGB statement in court in the video, and that can be used as real evidence. It's deadly for the Crown if they have it, and it's deadly against the Crown if they don't have it in a domestic case. Con statement, KHAN, it's got nothing to do with Star Trek. These are statements typically made by children in certain circumstances. Even though they're not sworn, they can sometimes be admissible if you meet specific criteria.
Beyond admissibility, how does relevance factor into evidence?
Relevance is just as important as admissibility. Even if the evidence meets the rules, in other words, it's direct evidence, it must be directly related to the case and not to a collateral issue. For example, bringing up unrelated details about someone's past does not usually help and can sometimes hurt their case.
So, what role should clients play in gathering evidence for their lawyer or counsel?
Our client should provide their lawyer with a detailed list of all potential evidence. The client needs to let the lawyer do their work and decide what's admissible and relevant. That's part of the lawyer's expertise. Trying to determine this on your own as a client will lead to mistakes, miss opportunities, and will certainly frustrate your lawyer.
Richard, this has been so informative. Do you have any final advice for someone that is currently preparing for trial?
Focus on working closely with your lawyer and do it early in the process. Be thorough and provide all the potential evidence that could be useful, but trust your legal team to decide what to present at court. And remember, the rules of evidence exist to ensure a fair trial for everyone.
Thank you so much, Richard. And thank you to everyone else for watching Legally Speaking. Be sure to comment and subscribe for more legal insights.
Thanks, Melanie. See you next time, everyone.
Thank you for tuning in to Legally Speaking, proudly brought to you by Aitken Robertson Criminal Defence. We represent clients facing criminal charges all over Ontario, providing you with legal support and dedicated advocacy. If you enjoyed this episode and want to see more content, please like and subscribe to our channel. For more information, visit our website. We also offer free books on various types of criminal charges, which you can request on our website or by using the QR codes on your screen now. For legal assistance, call us today or visit our website to request a meeting with one of our experienced lawyers or licensed paralegals. Thank you for watching, and we'll see you next time on Legally Speaking.